Dr. Simranjeet Kaur Gill, Professor of Law from City University, Ludhiana. Today, we will discuss the topic Scope of Jurisprudence with Other Disciplines. To know the relationship of jurisprudence with other sciences, one must dig deeper into the meaning of jurisprudence and its basis. Jurisprudence literally means the theory and philosophy of law, in the study of law in a reasonable manner. The word jurisprudence is derived from the Latin word jurisprudentia, where juris means law and prudentia means forethought or knowledge. Thus, jurisprudence can also be referred to as a knowledge of law. The origin of this subject can be traced back to the time of the ancient India, when the Dharmashastras were used as a source of individuals' conduct of people. As the concept of jurisprudence went on to develop further, different theories and schools arose and different scholars who propelled different schools of thought associated with it as well as criticized it. This is how this subject developed till 21st century. After the meaning of any subject, it is imperative to know the importance or significance of the same. The subject which we are talking about is a subject from which most the present law finds its origin and skeletal framework. If a person wants a deeper understanding of any law, then jurisprudence of that particular law enables one to do that. The philosophy behind it gives a better insight of the subject. It provides us with the various theories and analyses which rationalized the subject. It also gives a better understanding of the role of a subject. Jurisprudence help in understanding why a particular law is important and what role it plays in society. Jurisprudence does not limit itself to the development and evolution of law, but also contributes towards development of other social sciences, which in turn leads to overall development of society. Jurisprudence is often referred to as the grammar of law, for it helps people in the legal field to interpret a law better by giving a basic reasoning and the ideas behind a certain law. This provides an actual meaning of law and makes interpretation easy. The theories of jurisprudence helps in the practical application of the same. Relationship of jurisprudence with other social sciences. Jurisprudence often draws upon insights from the social sciences, such as sociology, psychology, anthropology, and economics, to understand the impact of law on society and human behavior. For example, legal scholars may use social science research to study how laws affect individuals and communities, how legal systems evolve over time, and how legal decisions are influenced by societal norms and values. Jurisprudence and political science. Political science is a social study which investigates the power, functions, and institutions of the states and theories related to it. Jurisprudence studies the law, and political science studies the dynamicism of the state. The concept of law came in because of the concept of state. After the state came into being, concepts such as laws and way of regulating individuals' conduct came into existence. Thus, jurists on various instances take help of theories and nuances of the political sciences to formulate theories related to the development of law. Political science also studies the rules and orders for regulations of people in a defined territory, which is also a subject matter of jurisprudence. Political science enunciates the principles behind the organizations of a state and jurisprudence, analyzes them and formulate concepts of law. There is an intimate and definitive linear relationship between the two. Friedman, in his book Legal Theory, emphasizes the interdisciplinary nature of jurisprudence. On one hand, jurisprudence is connected to philosophy as legal systems are built on fundamental principles and values. On the other hand, jurisprudence is linked to political theory as laws and legal systems are shaped by the political institutions and the government policies. Political sciences and the jurisprudence have a close relationship since legislators, who are responsible for making and amending laws, are elected by the people for whom the law is intended to govern. For example, the two houses of parliament comprising India's legislative body are chosen by the people of India, implying that the laws they enact ultimately reflects the desire and requirement of the people. They often overlap as they both study the organization and functioning of society and the state. The state is a political entity responsible for creating and enforcing laws, maintaining order, protecting individual rights, and providing public goods and services. Jurisprudence concentrates on law and legal systems, while political science examines the political system and government overall. Both fields work towards the betterment of society and the well-being of its people through the governance and regulation. Jurisprudence and sociology. Sociology is the study of pattern and varied norms of a particular society. The objective of such a study is to analyze the social behavior of a human beings in a particular society. It is a known fact that law is an integral part of any society, since it acts as a tool for regulating the individual of a particular society. A French philosopher, Auguste Comte, believed that jurisprudence is an integral part of sociology, and the law cannot be studied in isolation from other social institutions and must be viewed in its social context. He defined sociology as a positive science that deals with social facts. In his view, the study of law should be guided by the principle of social science, and the legal system should be analyzed in the terms of their social functions and their impact on society. Comte emphasized the importance of the understanding the relationship between law and society, and believed that legal institutions and practices are shaped by social, economic, and political factors. As jurisprudence is concerned with the study of law, it must also take into account the impact of law on society, including the social, cultural, and economical factors that shape the development and application of the legal system. This is because the law is applied to people and adapts to their changing needs. Therefore, jurisprudence deals with practical functioning of law in society. The application of law relies on the social interactions and behaviors of people within the society, meaning that without the social interaction of the people in society, the law would remain merely a theoretical concept, devoid of any practical use. For example, only when the people in the society socially interacts with each other and commit offences or crimes, the law comes into the place. Therefore, it is crucial to understand the changing needs and behavior patterns of the individual in society in order to develop law that effectively regulate and govern their conduct. This is where sociology comes into play, as it helps to provide insight into the social interactions and behavior that can help the development and application of the law. Criminology is an interdisciplinary field that draws from both sociology and law. It examines the motives, aims, and the theories of punishment, as well as the type of punishments, with the help of sociological insight. In this way, criminology is an example of how sociology and jurisprudence intersect and inform each other. Sociologists often refers to jurisprudence for a better understanding of society, as law and society are also intricately related. Law acts as a tool for the social change, and society instigates legal change. For example, the Nirbhaya case in 2016 or the Arab Spring, a crime happened in the society, led to a big change in the law. Another example related to law as a tool for the social change will be, for instance, abolition of dowry, which criminalized an existing social practice. This makes the interdependence clear between not only sociologists need an understanding of law to understand social pattern better, but to understand law and theories related to it. Jurists need to read into sociology for the reasoning of societal pattern on the basis of which law will be implemented. A separate school of thought in jurisprudence, mainly sociological school of law, exists to undertake legal studies from societal point of view. Jurisprudence and economics. Economics refers to the science of finance and wealth. It studies the financial aspect of society and carries out an analysis of the economy in general. The goal is to work towards development and welfare of that society. This subject works towards better living standard of the people by analyzing the financial system of the country they reside in and the causes and consequences of it. It studies the need and wants of people and how to fulfill them on a financial front. Jurisprudence studies and works towards fulfilling the needs and want of a people on the legal front through legislations. The end goal of both the subject is the same, and that's how they form their interdependence and interrelationship. One more thing they have in common is that one reason for the increase in certain areas of crime is because of wealth. There are various economic crimes such as white collar crimes. Crime is a subject matter of jurisprudence. This is the second point of commonality between the two subjects, and that's how much they are integral in each other's subject matter. The relationship between economics and jurisprudence was unrecognized for a long time, but it became apparent to many jurists later. While economics deals with the concept such as money, wealth, distribution, and satisfying people's need, the law's purpose is to regulate people's lives through rules and regulations. A good example is the GST Act, which regulates the taxation of various economic activities such as the sales of goods and services, import and export of the goods, and supply of goods and services by e-commerce operators. Money or the desire for it can be motivating factors behind the criminal behavior. For instance, someone may commit theft or fraud in order to obtain money or engage in cybercrime to steal personal or financial information for monetary gain. The relationship between economics and jurisprudence can help to understand the reasons behind such criminal activities and how to effectively regulate and punish them through the legal system. Economic theories such as the law of diminishing marginal utility can be applied in the legal field to help understand human behavior and decision making. According to the Alfred Marshall, the law of diminishing marginal utility is defined as the additional benefit which a person derives from a given increase in the stock of a thing diminishes with every increase in the stock that he already has. For example, this concept can be used to understand why someone's satisfaction might decrease as his wants or needs increase. Risk, which is another economic factor, can be used to understand why someone might commit a crime for the financial gain, even if it means taking a significant risk. By understanding the underlying economic factors at play, legal professionalism can make more informed decisions and create more effective policies and regulations. Jurisprudence and psychology. Psychology is the science of human minds and their behavior. The rationale of this subject is to understand the logic and the reasons of extremes and ranges of behavior in an individual, the causes of certain behavior and the impact of it on the body is the subject matter of this area of study. Jurisprudence also in a way studies human action. It studies law, and the law is formulated and comes into picture keeping in mind the implications of that law on a community. Regulation of a human conduct is not possible without understanding nature and what can be possibly transpire in the mind. Here, jurisprudence takes help of psychology and tries to understand the implications of law on society better, and thus formulation of law become an easy process. The impact of a certain law on a society should be a lawmaker first priority. This will ensure that law is executed properly and is followed effectively by the people concerned. For instance, if we look into criminology, the theory of deterrence under the theories of punishment is made with the objective of creating a fear in the minds of other members of society by confirming and rendering harsh punishment. They use psychology to control crimes in society. Another example will be of the elements of crime. One of the essential elements is the intention of committing an offense, mens rea. These examples show us well how these two subjects are intertwined with each other. Jurisprudence and history. History is the study of the past events and that happening in a society. Jurisprudence also studies the origins and the development of law with study of the past happenings in the legal field. There is a separate school of thought in jurisprudence with respect to history as well, namely historical school of law, which shows the integrity of both subjects so well. Jurisprudence is complete without the history, narration of past events. Since law did not originate in one night, it needs to look into its history. History plays a very important role in understanding the social and the cultural factors in which law were created and applied and how they have been interpreted and enforced over the time. It can provide insights into the values and beliefs that were prevalent at the earlier times and how they have evolved over the time. Learning to changes in the legal practices and regulation, it also helps in identifying patterns and trends in the legal system and how they have influenced the development of society as a whole. Since most misconducts are committed by the people, a similarity in the acts or pattern of behavior could be ascertained by observing history. To take an example, the Dowry Prohibition Act 1961 in India was enacted to prevent the practice of dowry, which has been cultural practice in India. Prevalent for many centuries, the act was a response to the historical and social context in which dowry was seen as a social evil and a major cause of violence against women. Jurisprudence and ethics. Ethics is the study of human conduct, as it deals with the theories of ideal human conduct. These ideals derive from the opinion of the majority of the society. The majoritarian's idea of what is right and wrong derives ideal human conduct. The basic moral values of the society that defines an ideal human conduct as morality is a major part of the subject matter of jurisprudence. Ethics studies the values that defines ideal human conduct, and jurisprudence deals with the history and evolution of such conduct, which regulates society. A jurist needs to understand the theories and science of human conduct, basically the notion of idealism in respect to the proper human conduct, to understand and analyze the law better. This close interconnection has led to another altogether separate branch of jurisprudence, namely ethical jurisprudence, which discusses the ideal human behavior and law as a tool to achieve that. Roscoe, a legal scholar and a jurist, argued that ethics and the laws have different aims. Ethics is concerned with the individual character, development and promoting virtuous behavior, while law is concerned with the regulating social behavior and maintaining social order. While the two are related, they are not the same. Pound believes that developing a strong ethical foundation is important, but the law is necessary to ensure just and orderly society. Ethical standards are often subjective and may vary from the person to person, depending on their beliefs and values. However, laws provide clear guidelines on what actions are legal and illegal, regardless of the individual opinion or arguments. Although many consider ethics and law to be separate concepts, they can also be interconnected. Ethics is a science of a human conduct, while the law regulates human conduct. It can be used as a standard to ensure just and fair law for the betterment of the people in the society. Ethical behavior is a fundamental to the proper functioning of a legal system and the creation of just laws. When most people in a society behave ethically, instances of misconduct and disagreements are likely to decrease. Creating a more stable and cohesive community, this ensures peace, harmony, coordination among the people. For instance, in an ethical society, people know that stealing is wrong, so fewer regulations and laws are needed to prevent it. However, in a society where stealing is rampant, stricter laws and regulations are necessary to deter individuals from engaging in such behavior. This demonstrates how ethical values and principles can influence the creation and enforcement of the laws, while the legal system can promote ethical behavior in society. In concluding remarks, the various social sciences cannot be read in isolation form. Other disciplines, these subjects are interdependent and interlinked in a way that study of one is incomplete without the study of another subject. If we look into the objective of all other social sciences, these subjects were made to study the society and its members from different fronts, that's political, social and economic fronts. To understand the theory of law completely and to apply it in the practical world, it is important to understand the basics of society and its members that comprises it. This will make the study and its application easiest. Jurisprudence is a broad and multifaceted field that has connection with the numerous other sciences across various disciplines. A complete understanding of society and its member requires the study of various domains such as politics, economics and social behavior in order to formulate laws suitable to that society. These different fields of study share a common objective of understanding the society and human behavior, and their interdependence is vital to gain comprehensive understanding of the complexity of the human behavior and the societal structures. Thus, jurisprudence play an essential role in the interdisciplinary study of social sciences, contributing to the deeper understanding of the legal principles and their broader implications for the society. Thank you viewers for watching this program.